Hello everyone, welcome to Court with Krissy. Time for an update. The F-bomber is back, and it seems that things have gotten worse since he's been bound over to circuit court. He has to appear from his cell with a tablet, and it doesn't go very well. But Judge Elmore, he's going to help make it better. As always, if you happen to miss his first appearance, link is in the video, as well as in the description. I hope you like it. Court with Krissy is now in session.
All right.
Hey, folks, thank you. Take your seats. All right. Is that Mr. Zapkis?
Yeah.
All right. Folks, good morning. We are on the record today for the 28th Circuit Court here in Wexford County. We're going to begin by taking up case of People of the State of Michigan versus Nathan Carl Zapkis.
Yeah, as soon as you drop them charges, we can talk about it. If you don't fuck them, they'll be walking in the park. So as soon as you drop them charges, we can talk about it.
All right, appearances, please.
Joanna Carey for the people.
Robert Hartel from Mr. Zapkis, who joins us by Zoom from the Wexford County Jail, Your Honor.
Thank you. We are here today for a pretrial conference. I began to conduct that in chambers with counsel. The court was informed that there were issues again with Mr. Zapkis and his ability to communicate with counsel.
Suck my dick. Suck my dick, and I'm setting this down. When you drop the charges, I'll fucking talk about it. You can't fuck with no way walking in the park. Watch this. Come get that.
All right, so we had some expression of discontent from Mr. Zapkis, who continued.
Shut your bitch ass up. Like I told your stupid ass, you don't fuck with nobody walking in a fucking park. I don't give a fuck. Get away from me. I set the thing down. You see this right here? See that right there? Face down. Bye-bye.
At this time, I'm going to ask the court clerk to hold on. Mr. Zapkis, sir, are you able to see and hear the court? All right, Mr. Zapkis says, can.
Tell nobody I said, oh, all right, fuck you. That's just another way to support.
All right, Madam Clerk, you may now mute the defendant. Okay, the defendant's still on Zoom. He still has a device where he's able to hear the court. In case it was unclear or difficult for the court reporter to get that, the court heard the defendant express several profanities and several suggestions to what this court or this judge and those here could all go do to themselves, maybe in a private room. I'm not so certain, but at least do to themselves things that probably would be inappropriate. This has been a very consistent type of conduct for Mr. Zapkis. The jail was even unable to put him in constraints and bring him over to the courthouse today. And this has become a significant pattern for Mr. Zapkis. At first, the court had thought maybe this conduct for Mr. Zapkis was just indicative of character. However, after speaking with both counsel and also receiving information from corrections officers from the Wexford County Jail, the court is quite concerned for the mental health of the defendant. Therefore, sua sponte, this court is going to order that the defendant continue to remain in confinement. His conduct is extremely inappropriate, extremely volatile, and it's clear because of his inability to control that volatility that he is potentially unable to assist the defense counsel in representing him. Any objection to that or anything further to add, Mr. Hartel?
No, thank you.
All right, thank you. Ms. Carey, well, I know the people don't represent Mr. Zapkis. Do you have any objection to this court ordering a competency evaluation?
I do not.
All right. Now, the next question here that typically follows in this kind of situations is whether or not the court should order a criminal responsibility. I don't know much more about the defendant. I know that he has extensive criminal history that has, because he's obviously got a habitual offender, a fourth offense enhancement on the felony information. Looking at an assault resist a police officer. Ms. Carey, what else can you tell me about the defendant's prior criminal history? And while the counsel are looking that up, for the record, on the Zoom screen, after we muted the defendant, he has continued to use the phone or the tablet or whatever they have provided to him there at the jail. We've seen it moving around, flashing different parts of the room, him moving around, him yelling and screaming, and his face occasionally appearing on the screen. So again, the court is quite confident he's making the appropriate decision, at least for a competency to stand trial. Ms. Carey, what do you have there?
2006, we have aggravated stalking and attempt home invasion first. Also in 2006, a domestic violence. 2008, domestic violence. 2009, domestic violence. 2009, stalking. 2010, CSE second. 2015, failed to comply with SORA. 2019, attempt to interfere with electronic communication. 2021, disorderly person. 2022, assault and battery. 2022, no ops on person. 2022, attempt assault and battery. 2023, resist and obstruct a police officer and trespass. Note too that the behavior that he is exhibited today and throughout the court proceedings is very similar to the behavior alleged by the police on the date of the incident.
Mr. Hartel, are there any diagnoses previously that might help the court have a better insight as to the criminal responsibility element?
Yes, Your Honor. I do not have proofs on me based on my past representations of Mr. Chapman, because I have represented him in the past. I do know that one of his mental health conditions is schizophrenia, just so the court is aware.
Okay, yeah. I thought I'd remembered something like that from his past. One moment here as I take a quick look at something else. So the question that I'm considering now is whether or not the court should order the defendant for a criminal responsibility evaluation. But the question is obviously the insanity defense, the criminal responsibility defined as the result of a mental illness and the result of having intellectual disability, where he or she lacks substantial capacity either to appreciate the wrongful nature, the quality of the conduct, and his ability to conform his conduct to the requirements of the law. From what I've seen, I'm really quite concerned because he can't even comply with corrections officers, and allegedly from some of the prior criminal history, he's got issues with line as conduct with the law. Mr. Hartel, you haven't entered a notice of a criminal responsibility defense. What is your position on behalf of the defendant?
We asked the court to order that evaluation as well, Your Honor, if it was suitable to the court and the people for this to be my verbal notice to the people.
Yeah, I'll accept that. Well, I'm sorry, hold on. I'm going to tell you that I think you're still required to file notice, and so that I'll direct you to please do that. But at least for today's purposes and the interest of judicial economy and my observations of Mr. Japkus and what everyone's telling me, what I've seen repetitively from him, I'm very concerned about his mental health and his whether or not he has a mental disease or defect that intellectual disability that causes him unable to perform its conduct, whether it's in the future, but really it's whether or not it applied at the time of the alleged misconduct. Therefore, this court will also order that the defendant will be continued to be held in custody and will also be examined by the Center for Forensic Psychiatry for criminal responsibility, in addition to competency to stand trial. All right, today we were scheduled for a pretrial conference, and then effectively, that's where this conversation came out of. Obviously, there's no resolution to the case today. I don't have any notice of motions, but of course, if there are any motions, Mr. Hartel and Ms. Carey proceed with those. This case will continue to be set for the final pretrial conference until I sign the document that will obviously move that to allow him to have the evaluations. As we go forward, of course, there's some responsibilities. I encourage both parties to put some ticker on your calendars to make sure this court is continuing and we're all continuing to check up on it within the required amounts of time. Sometimes when we put matters into this position, they tend to fall into the crack. I will make sure that I am occasionally reviewing it. All right, hold on one moment. All right, anything else on behalf of the people, Ms. Carey? How about you, Mr. Hartel, on behalf of the defendant?
So, thank you.
And I understand it's very difficult not having the defendant here. Today was originally just, like I said, a pretrial conference. Anyways, his conduct made him unable to be here. The court is electing not to hold the defendant in contempt because now of this repetitive type of conduct, and I think I held him in contempt previously. I'm now very curious about his mention of mental health, so therefore I don't think it's appropriate for me to address a contempt issue. Thank you. We're adjourned. Oh, wait, hold on. Hold on.
Are you continuing the previous bond that was set, or are you revoking that bond?
I'm revoking the bond, and I'm doing that. The court is reviewing that sua sponte pursuant to Corporate Law 6.106. I believe the subsection is subsection H, based upon the volatile nature of the defendant's conduct. He presents a significant risk to himself and to others out in the community. I can tell you that if he were found anywhere in the courthouse, I'd order the courthouse be locked down. So the answer is the court's revoking bond as well. Thank you. We are adjourned.